Hello, Colin Manning here again. In this video we're going to look at Chapter 5 of the GDPR. And Chapter 5 deals with the transfer of personal data to third countries. And this is quite a big deal. So if you are a data controller, you can engage processors anywhere in the EU. Just as there's a free market for goods and most services, data processing can be done across borders. So if you're an Irish controller, you can engage a French company to do your data processing. If you're a German controller, you can engage a Spanish company to do your data processing. But if you want to process personal data of people in the EU, outside of the EU, that gets complicated. And this can be especially problematic for multinational corporations that have offices in many countries and have data moving around hither and yon. So the GDPR proposes a fairly simple on the face of it solution to this problem. Countries outside of the EU that want to process the personal data of people in the EU can apply to be certified, and this certification would state that their processing is sufficiently good to provide protections. And so the EU maintains a list of countries where the data processing regime is considered satisfactory. So what we'll do now is we'll look at some of the details of that, and they're set out in Chapter 5, Articles 44 to 50. So Article 44 says that any transfer of data which are undergoing processing after transfer to a third country shall only take place if the conditions laid out in this chapter are complied with. So you cannot process data outside of the EU unless you meet the requirements set out in Chapter 5 of the GDPR. So Article 45 specifies that you can do a transfer based on an adequacy decision. So if you're in luck, the country where you want to do the processing is on the nice list of countries whose data processing regime is considered adequate. So a transfer of personal data to a third country may take place where the Commission has decided that the third country ensures an adequate level of protection. So the EU maintains a list of countries where the data processing regime is considered adequate. And as you can see here, it's quite a short list at the moment. Given the extent to which it's integrated into the EU economy, it's no surprise to see Switzerland there. The Channel Islands that are sort of in the UK, Jersey and Guernsey are in there. The Faroe Islands are sort of in Denmark. And we have Andorra also, which is nestled between Spain and France. Surprising entrants in the top league are Argentina and Uruguay. And we also have Israel and New Zealand. Canada's adequacy agreement is a bit limited. South Korea will probably be next to be added to the list. Now, what's most interesting about the list, of course, is the countries that are not on it. So the EU will conduct research and determine whether a country's data protection regime is sufficient. This isn't something that individual data controllers or data processors have any input into. And as we go further down the GDPR, we get into higher and higher levels of abstraction. And so this is very much a macro issue that is negotiated at intergovernmental level. There are a number of factors that are considered, and some of these are quite obvious. And it's worth having a look at those. But as a data controller, you have really no input into what happens here. You just have to check if a country is on the list or not. So in addition to the general state of play in the country that we see in Article 45(2)(a), the country also needs to have one or more independent supervisory authorities that is responsible for ensuring and enforcing compliance with the data protection rules. In Article 45(2)(c), we can see that any international commitments that the country has entered into can be taken into account as well. And so, depending on the setup in the country, it will be added to the list or not. Now, missing from the EU's list of countries where the data protections are adequate are the United States and the UK. Now, prior to Brexit, of course, the UK didn't need an adequacy decision because it was part of the EU and controllers were free to engage processors in the UK and vice versa. However, now that the UK has left the EU, it will have to demonstrate that it has protections that are equivalent to those in the EU. Of course, on the very day the UK left the EU, its protections were identical. And I think it's fair to say that the UK has done quite a good job of protecting personal data. One of the areas it falls down is the extent to which the security services can gather data and process data in order to prevent crime or in order to preempt acts of terrorism that might be harmful. And it has been suggested that the UK doesn't do enough to protect the rights of data subjects in this particular area. So it will be interesting to see what happens when the adequacy of the UK regime needs to be assessed. If the EU were required to assess the data protection regime in the US, like it does everyone else, it wouldn't have a snowball's chance of meeting the requirements. And the data transfers between the EU and the UK have always been subject to a kind of fudge. Over the years, 2 different schemes were put in place. We won't go into the details of those, but the first was ruled unacceptable, and the second scheme that replaced it has also run into trouble. So transferring data on people in the EU to the US is quite problematic because the data protection infrastructure in place in the US is so weak. Fortunately, however, if the country where you want to transfer the data is not on the list, there is a mechanism you can still use to enable the processing to take place. So GDPR Article 46 sets out how it might still be possible to transfer the data. So in the absence of a decision pursuant to Article 45.3, so that's the adequacy decision, a controller or processor may transfer data to a third country only if the controller or processor has provided appropriate safeguards and on condition that enforceable data subject rights and effective legal remedies for data subjects are available. So there is a way out. So if you want to do processing in a third country, in the absence of an adequacy decision, Article 46.2 specifies the mechanisms you can use to allow that to happen. So the first is a legally binding and enforceable instrument between public authorities or bodies. The second is perhaps the most important, and that's binding corporate rules in accordance with Article 47. We'll look at that in a minute. Standard data protection clauses adopted by the Commission, so there's like a template. In Article 46.2e, we can see you can use an approved code of conduct, or indeed there can be an approved certification mechanism, together with binding and enforceable commitments. Now, Article 46.3 talks about the main mechanism then that controllers use in order to enable the processing in third countries, and that's a contract between the controller and the processor. And so specific data protection provisions will be written into the contract. Article 47 addresses binding corporate rules. So there may be a group of enterprises that have rules, and the members of that group are bound by these rules. But for it to work, these rules have to expressly confer enforceable rights on data subjects with regard to the processing of their personal data. And the following section, paragraph 2, is quite specific on what needs to be included in that. So we can see in this the documentation that's required. And we can see that it recreates in miniature many of the obligations that controllers and processors within the EU would have under the GDPR. So these binding corporate rules need to specify the structure and contact details of the group of undertakings, the data transfers or sets of transfers that are going to happen, the legally binding nature both internally and externally, the application of general data protection principles, and the rights of the subjects need to be explicitly enumerated. Now, in Article 47.2f, we have a very interesting provision here. So there must be an acceptance by the controller or processor established in the territory of a member state of liability for any breaches. So if an Irish company is transferring information to one of its partner businesses outside of the EU, all of this documentation must be provided. But if there's a screw up, the Irish company is on the hook for any liability. It must also specify the tasks of any data protection officer, the compliance procedures, the mechanisms for ensuring verification of the compliance, the mechanisms for reporting and recording of changes, and the appropriate data protection training that's been given to personnel. So the obligations here and the documentation that's required here are quite onerous. But of course, the alternative might be not processing the data at all outside of the EU. So if the data is going to be sent to a country where the government of that country doesn't regulate data protection sufficiently, then the group of businesses must decide to self-regulate and provide by themselves the equivalent protections to the data subjects. Article 48 is legally quite complex, but it deals with the issue of a court outside of the EU requiring data, typically for criminal prosecutions, that is held in the EU. And so this article says that that can only happen if it's based on an international agreement. So Ireland and the US, for example, have an agreement between them where they will offer mutual legal assistance. And if there is evidence in Ireland that is necessary for the prosecution of a case in the US, for example, well, then there is a process which the US can use in order to have that information transferred. And there's a process there, there's an agreement there. What Article 48 is saying that the transfer can only take place within the context of that process. So a court in the US can't just say, I want it, give it to me. They must go through the process. And there was an interesting case a few years ago where there was evidence of criminal activity on Microsoft servers in Dublin that were requested by a court in the US. And there was a process and a procedure for the requesting of that information, but it wasn't used. And so Microsoft quite reasonably said, well, it's not lawful for us to give you that. And the matter ended up before the courts. Article 49 specifies some exemptions to the rules about processing data in third countries. And one of the ways this can be permitted is if the data subject explicitly consents to the processing. Now, needless to say, the issue of consent is quite a complex one, but that consent must be explicit. So you must be saying to the data subject, your data will be processed outside of the EU in such and such a place. Are you okay with that? You must consent to that. Another scenario where it's acceptable without going through all the rigmarole is where the transfer is necessary for the performance of a contract. So if a consumer in Ireland goes to a website in the US in order to purchase some product, well, the information that's necessary for the performance of that contract may be processed. Now, of course, it may not be further processed, and no more data than is necessary for the execution of the contract should be processed. There may also be important reasons of public interest, or there may be the establishment, exercise, or defense of legal claims. There may even be scenarios where it's in the vital interest of the data subject, but the data subject is physically or legally incapable of giving consent. It would be fascinating to investigate if this has ever been used or how many times it's been used. But of course, it probably relates to scenarios that we could never hear about publicly anyway. One could imagine a scenario where a data subject is hit by a bus in California and there's a note in their wallet that says, in case of emergency, contact this person. And when they phone that person, it's a doctor's office. And maybe in such a scenario, the doctor might be able to lawfully provide information about that patient who cannot give consent to that transfer of data. But that's quite a contrived example, quite a strange one. Certainly, if you were relying on this, you'd want to have it very well documented. GDPR Article 50 is quite meta in its concerns, and it calls on the EU institutions to cooperate with other countries to promote data protection so that the standards of data protection afforded both by people in the EU and outside of it can be improved. Again, this is an intergovernmental concern that needn't worry any individual controller or processor.